Mr. Chief Justice, and may it please the Court, Sections 11 and 12 of the 33 Act expressly reference and enforce the registration statement and prospectus requirements imposed by Section 5 of the Act, 15 U.S.C. 77E. In construing the term such security, therefore, it's appropriate to look to the meaning of that same term as used in Section 5, the source of the prohibitions enforced by Sections 11 and 12. And it's undisputed that such security in Section 5 consistently refers only to shares that are subject to registration, never to exempt shares. Such security in Sections 11 and 12 should be given the same meaning. That reading is confirmed by this Court's decision in Gustafson, which held that it's more reasonable to interpret the liability provisions of the 33 Act as providing remedies for violations of the obligations it had created, not as imposing liabilities independent of the substantive obligations of the Act. Respondents' contrary interpretation would run roughshod over the core statutory distinction between registered and exempt shares, which is fundamental to the structure and operation of the 33 Act. And it would dramatically expand the scope of liability, disrupt the capital formation process, and upset settled expectations by overturning decades of case law and SEC interpretation consistently holding that plaintiffs must prove they purchased registered shares. Respondent can't identify a single case in the 90-year history of the Securities Act imposing Section 11 liability on exempt shares. Congress, despite revisiting the Act numerous times over the years, has been content to leave the law that way. This Court should reject Respondent's attempt to overturn that long-settled understanding. I welcome the Court's questions.
You mentioned 90-year history, but have we had direct listing before? I mean, that seems to be what's causing the problem.
We haven't had direct listing before, Your Honor, but certainly there are other circumstances, and it's undisputed that there are many other circumstances in which the tracing requirement, given the modern operation of the securities markets, is difficult or sometimes impossible for plaintiffs to satisfy. But that has not led Congress to change the law, and it has not led the SEC to adopt any of the possible mechanisms it could adopt to address that concern if it felt it should do so.
You mentioned the tracing requirement. Could you speak a little bit about where that comes from and why there's a tracing requirement?
Well, so fundamentally, there's no doubt that Congress intended and required there to be tracing and expected tracing would be required.
For each share, as opposed to simply saying there's registration and as a result of that, the stocks are being sold.
Because again, the core distinction in the Act is between shares that are registered and shares that aren't. So, for instance, putting aside the issues in this case, Section 12A1, which creates a cause of action for unregistered shares. In order to prevail on that cause of action, a plaintiff obviously has to prove that they purchased unregistered shares, not registered shares. That's been in the Act from the beginning. So there's no doubt that Congress knew that plaintiffs would be required to trace. The same is true under Sections 11 and 12A2 for all the reasons that we've articulated.
Finally, why do you think that 11 and 12 rise and fall together?
We do, and this Court's decision in Gustafson, I think, makes that same point. A core rationale of the Court's decision in Gustafson, as I said, is that the liability provisions imposed by Sections 11 and 12 should be construed extensively with the obligations they enforce. The obligations they enforce arise under Section 5, which imposes an obligation to register particular securities, the shares that have to be registered, and requires a prospectus to be delivered only in connection with particular securities, namely registered securities.